The media is constantly telling us it is concerned about the loss of credibility and trust the public has in it. I suggest one way to avoid a further decline is to stop publishing flaming dumpster fire articles devoid of fact. It's just a suggestion. But instead, yesterday, the noted financial icon, Wall Street Journal, a paper that the name brings up integrity. You should be able to trust it. Yeah, you know it has a slant on its opinions, but by God, these people know what they're talking about when it comes to finance, law, business, politics. It's an incredible reputation. But what they did yesterday was pick up a festering, putrid, hot pile of nasty garbage, throw it into a dumpster, cover it with gasoline, and light it on fire and watch that dumpster fire burn. I'm talking about the article they published called Twitter's Lawsuit Against Elon Musk Looks Like a Loser. Now, this isn't to say the case is strong or weak. That's not to be decided yet. Musk hasn't even filed his response. However, they list a series of arguments purportedly based on the law to support their position, and all the contentions are absolutely ridiculous. It's jaw-dropping how bad it is, and it's a good piece to show when you read something in the media, you need to have some skepticism brought into it, because I don't know why they do this, what the agenda is. It's sloppy. Are they in a hurry? Do they have some other purpose for doing this? Whatever. It's all a bunch of BS. And let's walk through it and show just how a major newspaper will willingly publish to the public just a screaming, hot, flaming, nasty, smoking pile of garbage. Now, one of the problems Musk faces is the clause in the agreement that calls for the remedy of specific performance. In other words, the court ordering him to go through with the deal or ordering Twitter to go through with the deal. That's a big deal, okay? That's a serious remedy in the agreement. So how do they deal with it? They say it's used fleetingly, and it wouldn't really make sense to have such an order against Musk if he didn't want to do it. So the court's not going to do it. I mean, that's just something they're not really going to do. But what does the court say about it? This case is in the Delaware Chancery Court, and Chancellor McCormick is assigned to the case. She issued a written opinion in 2021 that said this: a party seeking specific performance must establish that a valid contract exists, he's ready, willing, and able to perform, and the balance of equities tips in favor of the party seeking performance. This court has not hesitated to order specific performance in cases of this nature. It doesn't say fleeting, rare, or we won't do it if we don't think he wants to do it. If he doesn't want to do it, we won't make him do it. It does not say that. And she goes further on to say, particularly where sophisticated parties represented by sophisticated counsel stipulate that specific performance would be an appropriate remedy in the event of a breach, which is exactly what the merger agreement states here. So the Wall Street Journal article completely ignores what the actual court says, completely ignores what the agreement says and how that court would interpret it, to instead substitute their own fantasy and imagination that they won't make him do that if he wouldn't want to do it. So there's no basis for that opinion. It's just hot garbage. So having dismissed specific performance without reciting any authority for that, they move on to the next argument, which is Twitter's not going to be able to show any damages, bro. They're not going to be able to prove that they actually lost anything because of this transaction. So Musk walks away scot-free or with a nominal damages amount. And their argument is that in the normal case, you would say, well, he agreed to pay X for this. He backed out. Now it's only worth Y. The delta, here, there's your damages. I completely agree with that. And they say that, however, since the shareholders, who were the people who would have received the premium, are not a party to the agreement, then Twitter can't make that argument on their behalf, that it should have been made a party to the agreement or something should have put into the contract. In fact, it said, Twitter could have raised the stakes for Musk by including a requirement that he pay damages to its shareholders if he walked away. Then the shareholders could have sued for the difference, for the amount he agreed to pay and the price any other suitor would pay. But the merger agreement does not give shareholders this remedy. Then they go on at the end of the article to try and dunk on the people who drafted the agreement and said, I guess these lawyers just weren't smart enough. But let me read this final sentence again. The merger agreement doesn't give shareholders this remedy. Now, let's look at what the merger agreement does say. Did they forget? Were they too stupid to remember to put this in the merger agreement? And they just forgot that, hey, if he backs out of this, maybe we ought to have something in here about the actual appropriate amount of the damages. The merger agreement says this. In the case of liabilities or damages payable by parent and acquisition sub, that's Musk, It would include the benefits of the transactions contemplated by this agreement lost by the company's stockholders, taking into consideration all relevant matters, including lost stockholder premium, other combination opportunities, and the time value of money, which shall be deemed in such event to be damages of such party. Did the people who wrote this article even read this agreement? Why would you not address that? Why would you imply or boldly state that there was no protection for the shareholder premium put into the merger agreement because the lawyers just weren't smart enough to think of it? Now, there is an argument whether the damages could be capped at the parent termination fee or not. That's beside the point of the walk-away termination fee situation. However, the agreement says you can't have both. You got to elect one or the other, specific performance or damages. And this lawsuit is over specific performance. So the $1 billion termination fee is not at issue by provision of the contract or election of the parties. The parent termination fee would really only be a situation applicable in the event they were asking for monetary damages. So not the situation at all. The next straw man they set up to knock down is the $1 billion breakup fee, and say, would the court order him to pay this $1 billion breakup fee? They don't discuss whether it's actually applicable, and it is not. As I discussed in the last video that I made on this, if you actually read the agreement, the termination fee, the $1 billion, only applies to allow termination in a few sets of circumstances, just a few. Some are by Twitter, and they have to pay Musk the $1 billion if they leave. Say if they got a superior offer and walked away from his, they'd have to pay him $1 billion. There's a couple other ones. There's only one provision that Musk can exercise to pay the $1 billion fee and walk away, and that's as if the directors made an adverse recommendation against his offer. That's it. Every other termination for him is covered in some other part of the contract. The $1 billion breakup fee is a soundbite, but it doesn't apply to the circumstances of this lawsuit. So first of all, they're right. The court shouldn't order him to pay a $1 billion breakup fee because it has nothing to do with the circumstances of this case. But they don't draw that distinction. Instead, they go on and attack the $1 billion breakup fee. Again, a breakup fee that was negotiated between high-level attorneys, accountants, teams of people, etc. And they cite the old principle, which I agree with, which is the breakup fee, a form, say, of liquidated damages. It's not supposed to be a penalty. It's supposed to be a reasonable reflection of the damages of the breach of contract that is liquidated to avoid either side having to prove damages at a trial. So it can't be excessive. It can't be a penalty. And then they just conclude, with no analysis, that this $1 billion is obviously too high. It's a penalty. It can't be that much. So they substitute their own judgment for the judgment of Musk's team and Twitter's team, who both decided that would be a fair amount in either direction if one party were to walk, on a $44 billion transaction that easily can be worth $50 billion, $20 billion, or whatever. I mean, the amount of damages in this case to either side, if one party walks or something horrible goes wrong, easily can exceed $1 billion. So a $1 billion breakup fee in that context is certainly not excessive compared to what damages either party can cite. If you look at the shareholder premium, if Musk were to walk and he were to be found liable, it would be way in excess of $1 billion. So their argument is just on its face ridiculous, more hot garbage. And their final contention is that, hey, look, in these cases, when somebody breaches and they don't buy a company, it's really no biggie because the corporation, separate from the shareholders, which is certainly true, it just doesn't suffer any harm. It's never harmed by this. It's a rare event when that's harmed. Another accusation made without any evidence, which is ridiculous, I think, for people who've gone through M&A activity to think that there's no damage. Now, that's not to say it's a whole lot of damage, but no damage through engaging in this process and having an executed contract materially breached, not a letter of intent, not a walk away after due diligence, but an executed merger agreement that is materially breached results in just no damages. It's not a big deal. That's ridiculous. It also further underscores the fact that earlier in the article they don't even refer to elements of this agreement where they provide for the shareholder premium, provide for the limited circumstances where a party could walk for the breakup fee. They just ignore all language of the agreement, any of the law coming out of the Delaware courts, and make this proclamation. It's pretty bizarre because it was in the opinion section, and if you read the Wall Street Journal, they do have articles which dive into this lawsuit that actually deal with facts, what's actually going on, and etc. But again, just be careful when you're reading mainstream media, whether it's Washington Post, Wall Street Journal, and they're giving you their opinions on things, and sometimes even when they claim they're facts, you don't know why they're doing it, and you don't know the quality of it. Always have a skeptical mind to what is being pumped out of the media these days. And that's it. Thanks.